Good morning.
Morning.
Okay, good morning, everyone.
Good morning.
So we'll go ahead and start oral arguments in the case of State versus Elma. I know the state's appeal was dismissed, so we'll proceed as if the cross appellant is the appellant. So Mr. McLean, you'll have an opportunity for the opening argument and rebuttal argument. You'll each have 20 minutes aside. Mr. McLean, how much time would you like to reserve for rebuttal?
5 minutes, Your Honor.
Okay. And there is a clock on your, should be a clock on your screen to help you out. The other members of the panel, of course, Judge Harris, Judge Sasso. I do want to advise both attorneys that the oral arguments are being streamed live on YouTube so that the public does have access to the oral argument. And with that, we'll go ahead and proceed.
Good morning, Your Honors. Matthew McLean on behalf of the cross appellant, Edward Elma. Today, there's no question that Mr. Elma was provided with ineffective assistance of counsel that resulted in the loss of a favorable plea offer. The only issue today regards whether the remedy afforded by the court was appropriate and under the circumstances of this case. The remedy provided by the trial court was to vacate the convictions, place Mr. Elma back on the trial docket, and to have the state encourage them to renegotiate the case in good faith. The problem with that remedy is it does not put back Mr. Elma in the position he would have been, but for the ineffective assistance of counsel. If we think about the position that what Mr. Elma would have been in, he would have been in a position where there was a plea offer of 38.7 months. He should have known that the offer would have entitled him to gain time, and he would have known that the statutory maximum in his case was life in prison. Knowing those circumstances, he testified and the court accepted that he would have accepted the plea offer. The state would not have withdrawn it prior to its acceptance, and the court would have accepted as well. The practical remedy under the circumstance is for the state to reconvey that offer, the exact terms, so Mr. Elma can go ahead and accept it. The problem with the remedy provided by the court under these circumstances is that it exposes Mr. Elma to a new trial, to a maximum sentence of life in prison, and all of this because his attorney provided him ineffective assistance of counsel. Through no fault of his own, he unknowingly rejected a favorable plea offer.
Mr. McLean, is it your position that the remedy is to be in accordance with what was set forth in Lafler versus Cooper?
Yes, in Lafler v. Cooper, the United States Supreme Court addressed the different remedies that can be afforded under the circumstances. And Mr. Elma's case fits under the second set of circumstances established in Lafler v. Cooper, and specifically that the offer be reconveyed. Because
now, if the offer is reconveyed and your client were to accept it, would you agree that under Lafler, the judge could sentence your client to the 38.7 months or up to 6 years or somewhere in between?
That's what Lafler does state, that the court can go ahead and sentence the defendant up to, or maintain the 6-year sentence, or sentence them between the 38 months and the 6 years. However, that is kind of odd because the court has already found that under the circumstances, the offer would have been accepted by the court. So I would anticipate the court applying good faith would accept the 38.7 months on remand. But according to Lafler and Cooper, that is what is to be done in this circumstance.
So it's your position, it's your position that as a matter of law in every situation similar to this one, or just in this case, that the trial court would have to order the prosecution to reoffer the plea?
I don't think it's necessarily every situation. I think every situation is going to be different. And the United States Supreme Court discussed that in their decision that they provided just two circumstances that they believed could resolve the issue. There certainly might be some circumstances that might be different, but in this circumstance where he was misadvised about the statutory maximum and his right to gain time, the only remedy that can be provided to him is that he be provided that plea agreement once again, and not be exposed to the type of remedy provided in Lewis or in the second DCA decisions of Odegaard and Hunton. And Odegaard and Hunton, they serve as the proposition warning defendants to raise these type of claims because they should be afraid that they would be exposed to additional sentence greater than what they currently have and greater than what was conveyed to them. And we shouldn't be scaring litigants into filing claims of ineffective assistance of counsel to prevent them from doing so when through no fault of their own. Perhaps one of the most important stages in a criminal proceeding, plea negotiations, was inadequately done for them. I believe that the decision in Odegaard and Hunton need to be addressed by this court, and litigants shouldn't be afraid to file these type of claims going forward.
So just so I understand your argument, do I understand that you're arguing that Lafler is essentially binding on the trial court and the trial court failed to follow Lafler?
Yes, I believe Lafler is binding on the court, on the trial court. And not only that, but Alcorn also, which is the Florida Supreme Court decision that came after Lafler, specifically adopted Lafler v. Cooper and overruled this court's decision in Lewis. And when you look at the Lewis decision, which is from this court and was relied upon by the trial court, it was also operating under a different set of circumstances at the time. Under those circumstances, that's when the coddle line of principle was being used by the courts in lost plea offer settings. And the only thing that a defendant needed to prove was that they would have accepted the offer under the circumstances and that the offer was less than what was given.
Did Alcorn address, though, the specific remedy required other than, reiterating the language that the constitutional taint would have to be removed?
No, Alcorn did not. They specifically declined to address the remedy. They remanded the case back for a prejudice finding. And a lot of these cases that are subject to the remedy, they're all dicta in a sense that they're remanding them back for prejudice findings or other findings and passing on the remedy. So this case really presents a unique set of circumstances in which this court can clarify for litigants and courts what the appropriate remedy is when the actual remedy is at issue and not a moot point or not a right point.
Well, if your argument is based only on that the trial court misapplied Lafler and Lafler is binding on this court or on the trial court, and I guess you would also argue binding on this court, what wouldn't an opinion just look like whether or not the trial court actually applied Lafler correctly?
Yes, I think that's certainly an approach that this court could go ahead and take and bypass having to disagree with Lewis. I think this court can distinguish Lewis based off of Lafler, and also in Lewis, the Lewis court didn't say this is the only remedy that's available under the circumstances, just provided a remedy.
So in other words, you haven't argued in your brief, for example, that the court abused its discretion in choosing this appropriate remedy because it was insufficient to remove the constitutional taint, right? It was just the didn't fail to follow Lafler.
We argued both, that it wasn't a proper remedy under the circumstances because it did not cure the remedy caused, and we also argued that it misapplied Lafler and Alcorn under the circumstances of this case.
And so
let me ask you this, Mr. McLean. Lafler refers to some things the court can consider in the exercise of its discretion. Is it your argument that those factors are to be applied in considering the remedy, or is it your argument that those factors are to be considered in deciding, for instance, in this case, whether to go the 38 months or the 6 years or whatever in between?
I think that they can be applied throughout the analysis of a lost plea offer. Certainly, a defendant's willingness or unwillingness to accept an offer in the circumstances of that case can be applied, and certainly can be applied to do the remedy. The court in this case talked about the motion to suppress and whether by putting him back on the trial docket, that would put him back in the position closest to what he would have been under the circumstances. Respectfully, I disagree with that position because that does not put him back in the same circumstance he would have been. Under the circumstances, he would have been with the plea offer conveyed to him, knowing that he had a motion to suppress, and then he could then make a determination of whether to accept the offer, continue to litigate the motion to suppress, and go to trial. But the remedy crafted by the court is taking away the conveyed plea offer and putting him in a position of litigating a motion to suppress or going to trial without the 38.7-month plea offer. And
Let me ask you this. In Lafleur, they talked about the second category of cases, and this would appear to be a second category of case, and that is where the jury comes back with a verdict where the offenses of which the defendant is found guilty are greater than the offenses in the plea offer, which either call for reduction and to a lesser offense or dismissal of charges. And when they talk about the second category, they use the term may use this remedy. But then when they talk about Lafleur's case in particular, they say the correct remedy is. So it seems like in the general category of they talk about a may, but then later as far as Lafleur, they seem to be definitive that is the remedy to be applied. I mean, is it?
Yeah, yes, I agree, and I think the reason
where
why
does
they
that
use,
put this case? If that's a correct reading of Lafleur, where does that put this case as far as
I think
we're
it's
supposed to do
correctly under Lafleur, and I think the reason why the U.S. Supreme Court originally or first used the word may is because every state is different, and it was considering a Michigan case at the time, and similar to Michigan law, Florida law provides the trial court with the ability to reject a plea agreement that is brought to it. So under the circumstances similar to Michigan law, Florida has the same sort of ability afforded to trial courts to do that. So surely if the U.S. Supreme Court finds that to be the remedy in the circumstance, the same should be applied in this case. And interestingly, I provided supplemental authority from the Middle District of Florida, and it's the Klume case in 2020. I think it was decided in March, and it's the same district that Mr. Elmo would be in if he were to file a 2254. And in that case, similarly, the defendant was misadvised about the statutory maximum sentence faced, and the remedy crafted by the Middle District of Florida, who is applying clearly established federal law principles in a 2254 setting, comes with the remedy provided by Lafleur and states within 10 days, the state shall reconvey the same plea agreement provided to the petitioner in that circumstance.
Are you suggesting that the remedy is clearly established law?
I certainly would argue that based off of Klume, based off of Lafleur, it is firmly established under these circumstances that should be the remedy. That the remedy should not be, and I have trouble grappling with the fact why the state would advocate for a remedy that affords a defendant a second trial or an opportunity to second trial. The court affirmed his conviction and sentence on appeal. There was nothing found to be inappropriate in a 3850 setting for his conviction, yet this remedy crafted is providing Mr. Elma and the state possibly with having to redo a trial where there's nothing wrong with it. The remedy just doesn't make any sense in the circumstances. It's not nearly tailored. And then we also get
Mr. McLean,
that the remedy here is inconsistent with Lafleur, and we do an opinion in this case. What does the remand instruction in this particular case, as applied to Mr. Elma, what does the remand say?
I think it's similar to the instructions given in the Klume case in the Middle District of Florida, that it should be reversed and remanded for the trial court to order the state to reconvey the exact plea offer that was conveyed, and for Mr. Elmo to have the ability to accept that. And similar to Lafler's language, and the court would then have the discretion whether to accept that agreement or sentence him anywhere between 6 years and 38.7
But in
months.
this particular case, Mr. Elma has already served more than the plea offered amount, right? More than the 38 months.
No, he has not. He was given bond pending appeal. He has, I think, about to reach that 38.7 months, about a year to go. So if this court were to, if his claim were to have been denied, he would have had to serve another, 4 years of prison. But
I thought that
he currently only has time for, I think, about 24 months at this time.
And what happens to the conviction on the felony, the other charge, the possession of firearm charge?
Well, the appropriate remedy is to reconvey the exact plea offer. And so that plea agreement called for the null pros of that conviction. So what would happen is he would accept the plea agreement pursuant to what was originally offered, and then the court would then vacate the convictions at trial.
Mr. McLean, if we were to affirm the trial court's ruling and this remedy stood, would there be anything that would preclude your client from going to the Middle District the same way that happened in Clune?
It's interesting because in order to get federal review, you have to be in custody at the time, and your conviction has to be final in state court. So he would be put back in a position where he'd be on the trial docket. So procedurally, I'm not sure whether he would have the path to federal court under those circumstances, since he technically would not be under a sentence at the time.
Well, if he was convicted and got a sentence of 6 years or more, would then he have the same path as was available in Clune? Because I assume that's what happened in Clune.
So I think if in this situation, if Mr. Elma's 3850 was denied and they found no ineffective assistance of counsel, then he would have the ability to go to the Middle District of Florida where Clune was decided. And if that court found ineffective assistance of counsel, he would be afforded the same remedy as in Clune. Which is the remedy provided and crafted in the Lafler decision.
All right, you're down to 3 minutes and 40 seconds. Do you want to save the rest for rebuttal?
Yes, please. Thank you.
All right, thank you.
Good morning.
Mr. Bradford, you may proceed.
Thank you. My name is Robert Bradford. I represent the state of Florida in this case. May it please the court. I think one major point we have to remember is the standard of review in this case, and that is an abuse of discretion.
Well, is it an abuse of discretion if the remedy is inconsistent with Lafler?
I don't know that it would be inconsistent in the fact that Lafler says it may be appropriate, which implies that it may not be appropriate in certain circumstances to make that, to force the reoffer of the original offer. I think
in Lafler, the case fell within the second category that Lafler discusses, and they ended the opinion that said the correct remedy in this case is to make the plea offer, and then the judge could go anywhere between the amount of the plea offer or the amount previously ordered. But
well, in that case, Your Honor, I think even Your Honor alluded to that earlier. There was also two additional considerations that the Lafler court thought appropriate, not only necessarily when you're considering whether the defendant would have in fact accepted the original offer, but also when fashioning a remedy. And that is that in this case, the cross appellant's earlier expressed willingness or unwillingness to accept a plea bargain. And in this case, based on the testimony.
But Mr. Bradford, the trial court made a specific finding that the Alcorn elements have been established. And one of those elements is that if counsel had given proper advice, that Mr. Elma would have accepted the plea offer. So aren't we stuck with that finding of fact?
I agree, but I think the question goes to both that issue, which has been decided. I'm not trying to re-raise that, but also goes to the discretion that the trial court has in fashioning appropriate remedy. And in this particular case, because the cross appellant had turned down no less than four either opportunities to negotiate or actual offers, that I think goes to his willingness or unwillingness to accept responsibility. In fact, he went to trial, and his whole defense at trial was a gentleman named Papa was in his car, and Papa got out and left the drugs and the gun and the ammunition and everything else in the car, even though it was actually found in his passenger's purse, as I recall.
So let's say that we have to, we think that's baked into the cake just with the finding of ineffective assistance of counsel. Do you agree that Lafleur requires, as a matter of law, that the plea be reoffered in these circumstances?
No, I do not.
Okay, and why is that?
The other reason is because the second consideration of relevance that the Lafleur court pointed out was any and all evidence that may have come to light after the original offer was made. And in this particular case, if the court recalls, the second victim at the Crystal robbery, I think her name was Lena Navarro, she didn't testify at the suppression hearing, but she did testify at trial. And at trial, she identified the weapon, the revolver that was found in the appellant's bedroom with the appellant's wallet that the appellant's cousin said was his room. That weapon was identified by the other victim as the weapon used in the robbery. So you have that additional evidence and anything else that may have come out on top of the fact that up to that point, the cross appellant had turned down the opportunity to engage the state in a negotiation for a 36-month sentence with no minimum mandatory. He initially turned down the 38.7 sentence with the first attorney opting to wait for the motion to suppress to be heard. Then the second attorney came on board. The second attorney said that the offer was again or still on the table. He said his response at that time, the cross appellant's response was, can you get me 24 months? Or eventually, I think they decided just to go ahead and wait for the motion to suppress because that attorney actually added an additional ground of a Miranda violation with respect to the stop and the statements made.
Let me ask you this. Lafleur refers to that whatever remedy is chosen, the remedy is to neutralize the taint of the constitutional violation, not grant a windfall to the defendant, and not needlessly squander the considerable resources the state properly invested in the criminal prosecution. So in this case, does the remedy neutralize the taint of the constitutional violation, and does it possibly force the state to use more resources? In other words, is the remedy in this case consistent with those two goals outlined by Lafleur?
I think it was consistent with that in respect to putting the objective of the trial court was to put the defendant back in the same position he was in, the cross appellant at the time that the original offer was made. Now, again, it was being made at a couple of different times. And in fact, it went on and another offer was made for 50 months, which he turned down as well, closer to trial. But in this particular case, the reason I think he might even be in a better position, not necessarily the same position, because again, at trial, it came out that there were some irregularities with some of the drugs and the evidence that had been presented during the discovery process had actually possibly come from a different case. And also, if you go back to the original position he was in, he still has the motion to suppress, both based on the alleged unlawfulness of the stop and the Miranda violation once he was stopped. In this particular case, the motion to suppress was based on the fact that the stop was premised on the fact that the defendant and his passenger were not wearing their seatbelts. There was other evidence that came to light that I think during the evidentiary hearing, that the car the defendant was driving was in fact had tinted windows. The windows were up, and he said was even possibly illegally tinted. They were very dark, in other words. And so it was going to come down, as one of the trial counsel indicated, it was going to come down to a swearing contest, essentially, between the officer who stopped them and the cross appellant. That, I think, is, one has to keep in mind the fact that with these procedural irregularities and the way the officer testified at trial, the cross appellant may be in a better position to move forward and want to turn down another plea offer. In fact, there was, if the court will recall, this court relinquished jurisdiction shortly after the notice of appeal was filed by the state because the parties had reached a resolution, and then during the relinquishment, it apparently fell apart, and so the appeal proceeded. So,
can you point to any language in Lafler that supports the argument that ordering a new trial is the appropriate remedy?
Just the discretion of the trial court, Your Honor. As the Alcorn court quoted Lafler, they said
if that was the case, why does the Supreme Court even write an opinion in Lafler if the trial court has discretion to do pretty much anything?
Well, I think the Alcorn court addressed that in their opinion, and it said, with respect to the limits circumscribing the trial court's discretion, the United States Supreme Court expressly declined to set any such limits, instead stating eventually that stare decisis and principles announced in the opinions would guide the trial court's discretion.
Right. But in Lafler, they sent back with a remand with instructions that the correct remedy in this case is. That's not consistent with saying the correct remedy is go back and exercise your discretion.
Well, but then the Lafler court also stated that if the offer was accepted, the court could still then choose to do nothing with respect to vacating the judgment and sentence, or right, it could accept the plea bargain.
I mean, in this case, the judge has vacated the convictions and has ordered a new trial. Whereas I think in Lafler, the remedy was the judge could, sentence the guy and remand pursuant to the plea agreement, or not vacate the convictions. So this
that's correct.
To be a lot different scenario than the options that were set forth on remand in Lafler.
But in Lafler, we have no indication that there was a viable motion to suppress pending at the time that had not been adjudicated. We were not told that there was evidentiary.
But in this case, Mr. Elma could reject the plea offer, and then you are back to the new trial. But if he were to accept the plea offer, then Lafler suggests, the judge could still go ahead and maintain the same sentences and convictions before, or do something better for Mr. Elma. But where we are now in this case is there's no plea offer in front of Mr. Elma, and the case is, set for trial. So I'm trying to see where that's consistent in any way with the remand instructions in Lafler. That's what is concerning me in this case.
Well, I think, Your Honor, it's important also to recall, as we indicated earlier, that the cross appellant in this case has already turned down 4 definite offers in this case.
Mr. Bradford, you keep mentioning the offers that Mr. Elma's turned down, but isn't this case a little bit different? I mean, he made a counter offer, didn't he? That I'll take the 38.7 months if I get gain time, which he actually was entitled to. I didn't do it, but didn't he offer that? I'll go ahead and take it as long as I can get gain time.
I believe he said he would have taken it if he knew he was getting gain time.
Okay.
I don't recall that he actually said can you get me that? When the offer was presented by the second attorney testified at the evidentiary hearing that the response was, can you get me 24 months? Nothing about the gain time.
Presentation that he would have accepted the 38 months if he got gain time, which turns out he was probably entitled to. And
I
he would have
agree.
forced the motion to suppress. He would have just taken that. And again, this goes to what I was asking Mr. McLean earlier. I showed that he served 39.5 months before he bonded out. So he'd be done with this case. Does that make a difference in this case?
I think it does, in the sense that the Lafleur court and as it was channeled through the Alcorn court talked about not granting the defendant a windfall. And of course, if you got to remember in this case, because of these either evidentiary irregularities or some statements made by the trial court before sentencing with respect to not believing the Papa defense and what have you, the cross appellant only got 6 years. He was facing a life sentence on this trafficking charge under the HFO. And because of all of that, he got 6 years with a 3-year minimum mandatory on that count. So if you give him the 38 and cut that down in half almost again, basically, I think you're right. I think he's basically served his sentence almost, or close to it. I think that would definitely grant him a windfall, which Lafleur says you shouldn't do. We're looking for not to put him in a better position, but to neutralize the taint, put him back in the same position. And that's what the trial court tried to do. And in this case, with the leverage he now has with the motion to suppress and the credibility issues with the officer.
On the other side of the coin, though, is if the state doesn't offer, he's looking at life in prison, even though he got a sentence of 6 years, and even though the trial court found that if his counsel advised him properly, he would have received 38.7 months.
And he turned down 50 months with the expectation
But my
he was
question
running.
is, as of now, if the state does not make an offer, he's looking at life in prison under the remedy ordered by the trial court.
He could always plead blind, and the court could.
And again, looking at life imprisonment.
He would be facing life imprisonment on remand under the HFO. That's correct. Again,
let me ask one last question. Do you believe the remedy in Lewis is consistent with Lafleur, or do you think Lewis is still good law or not?
It's hard to say. I mean, certainly the trial court thought Lewis was still good law in the light of the fact that Alcorn, the issue really wasn't the remedy.
Well, yeah, let me limit my question to, do you think the remedy ordered in Lewis is still good law and consistent with Lafleur?
To the extent that,
I mean, Alcorn overruled Lewis, or quashed Lewis on the prejudice.
Right. Yes, sir, it did. With respect to, I think it to the extent that it leaves the court with the ultimate discretion to fashion an appropriate remedy. The factors, the target, the objective may have changed slightly in a semantic sort of way, but as far as the trial court's ability to fashion a remedy, I think it's still within the discretion of the court. And I think to that extent, Lewis is still good.
To follow up on that, do you think that Lafleur announced a rule that is binding on the states? In other words, does Lafleur announce as a matter of United States constitutional law that this is the only remedy available in these sorts of cases?
No, and as I was alluding to earlier, I think it's on page 429 of the Alcorn opinion that they actually quote, I'm sorry, they don't quote, but they interpret the Lafleur opinion as an express rejection of a hard and fast rule, that this has to be done in every case. They said that you just have to kind of go with the flow, and it's going to be a piecemeal, and every case is different. And so it's going to be a case by case basis. And I think that's why, and the fact that we have the motion to suppress, that we have the evidentiary irregularities in this case, that we have the instance of the cross appellant turning down 4 specific on the table offers in this case. He thought he was only facing 30 years. I mean, he was only a 20-year-old man, I think, or so when this happened. 30 years is still a long time out of his life. So there are no hard and fast rules. And quite frankly,
and so sorry to follow up, do you think then as a matter of state law, especially in light of the fact that Alcorn did not address remedy and only addressed prejudice, although it did adopt Lafleur in terms of prejudice, that the issue of what is an appropriate remedy under these circumstances is unaddressed, or do you think there's any binding authority on the appropriate remedy in these sorts of situations?
The Florida Supreme Court in Alcorn pretty much channeled a lot of what Lafleur said with respect to remedies as well.
In terms of, yes, right, in terms of, the general rule of removing the taint of the constitutional violation, but in terms of how that is accomplished, do you think that there's any binding authority?
I think, since it wasn't the actual holding of the case, well, as I've read before, it may be dicta, but it's from the Supreme Court, so it's pretty good dicta. I guess is how I would answer that. Does the court have any additional questions?
Any other questions? All right, thank you, Mr. Bradford.
Thank you, Your Honor. I think that the key here is to remember that no reasonable person could agree with the trial court in this decision as far as the abusive discretion standard. Thank the court.
All right, Mr. McLean.
Thank you. Just to Judge Harris's point about the time that Mr. Alma has served, you are correct with the 39 months. So if the remedy is to reoffer the 38.7 months, he would have time served for that. If it were not to be the case, then he could possibly face up to life in prison, which is not putting him in the same position he would have been. Regarding the standard of review, the state in its answer brief to the cross appeal never challenged the standard review set forth by Mr. Alma in his initial brief, which is de novo standard review, and believe de novo is the correct standard review because we're challenging the appropriateness of the remedy challenge. And we had to accept the trial court's finding of ineffective assistive counsel. And the claims were based off of not being advised of the statutory maximum and not being aware that he was entitled to gain time. That nowhere in his motion or at the evidentiary hearing did he claim that had he been aware of a motion to suppress, that would have caused him not to reject a plea offer.
So I know you reference that this may language references, may be applicable depending on the state law, but doesn't the Lafleur court, it references, the appropriate exercise of the court's discretion, and then the trial court can then exercise its discretion. And today's decision leaves open to the trial court how to best to exercise that discretion. I mean, Lafleur repeatedly refers to the trial court's discretion and suggests what may be an appropriate use of discretion in certain cases. But how do you read those multiple references to the trial court's discretion as requiring a specific remedy as a matter of law in this case?
I think what the U.S. Supreme Court was doing is that it wasn't able to account for every situation, but it specifically addressed two situations. And Mr. Alma's situation happens to fall under the second category, specifically addressed by the U.S. Supreme Court. And at
Is
the
that
end,
holding or dicta?
I believe it's the holding, because ultimately they reversed and remanded for the plea offer to be reconveyed to Lafleur. So I think what the U.S. Supreme Court was doing is setting forth general principles that the court does have discretion to craft a remedy. However, under these circumstances, addressing at least two of them, this is what the remedy needs to be. And again, the overarching principle is you need to tailor the remedy to the actual injury that happened. And in no way does what the trial court did tailor the remedy to the injury that occurred. It leaves him exposed to life in prison. It leaves him without a plea offer, and it leaves him in limbo. And the state addresses the relinquishment of jurisdiction. I think it's safe to assume that if the same offer had been conveyed, we wouldn't be here today, because that's the remedy that Mr. Alma was asking for, is the same offer to be reconveyed to him. And he's not asking for a new trial. He doesn't want a new trial. He doesn't want to be exposed to life in prison. Otherwise, he wouldn't be pursuing this appeal. So we're asking the court to find that Lafleur's binding precedent and to go ahead and order the same plea agreement to be reoffered to Mr. Alma. Thank you.
Okay,
Thank
thank you
you.
very much, and thank you both. We'll be in recess till 10 o'clock.